Madam Speaker, I want to address an extraordinary development that happened yesterday. Right before a Judiciary Committee hearing in which we ultimately voted to cite the Attorney General of the United States, Merrick Garland, for contempt of Congress for defying a congressional subpoena. Just minutes before this hearing happened, we received a letter from the President's Counsel, Edward Siskel, invoking executive privilege with respect to the materials that our committee has been seeking. Those materials being recordings of President Biden's interviews with Special Counsel Robert Hur. I want to take a moment to address just how absurd this invocation of executive privilege is. Indeed, I want to identify the 6 absurdities of this invocation of executive privilege. But just as a little bit of background first as to how we got here. In 2022, Attorney General Merrick Garland ordered an unprecedented raid of Mar-a-Lago, purportedly in search of classified documents. This became awkward for the administration when it was soon revealed that President Biden himself had various classified documents scattered about his personal properties. So Attorney General Garland, in an attempt, I suppose, to appear even-handed, appointed a special counsel, appointed Robert Hur, special counsel, to investigate President Biden's possession of classified documents. Earlier this year, we received the report from Special Counsel Hur, and the report found considerable evidence that President Biden had willfully obtained classified documents in violation of the law. He found evidence as to each of the elements of that criminal offense. I asked Special Counsel Hur, when he came to testify before our committee, I asked him a simple question: could a reasonable juror have voted to convict the president? And Special Counsel Hur answered yes. Now, it's important to note that while some at that hearing tried to cast aspersions on Mr. Hur's integrity, when Merrick Garland appointed him, he praised his long career and distinguished career as a prosecutor. Now, despite those findings, of course, Special Counsel Hur opted not to charge the president, citing his age and the lapses in memory that he displayed during his interviews with Hur. So the Judiciary Committee sought access to these records of those interviews, given the obvious public interest in matters pertaining to the Commander-in-Chief's competency, or for that matter, his potential criminality. And eventually, the Justice Department responded by producing redacted transcripts of President Biden's interviews with Special Counsel Hur. However, they continually refused to produce the actual recordings of those interviews, with shifting explanations over time, until the Judiciary Committee was forced to convene a hearing yesterday to cite the Attorney General for contempt because the subpoena that had been duly issued for those materials was being defied. Attorney General Garland refused to comply with it. So it was only moments before that hearing yesterday, after months of back and forth, that suddenly this letter lands from the White House that says, well, we are invoking executive privilege with respect to those recordings of President Biden's interviews with Special Counsel Hur. So I want to go through the 6 absurdities of that particular use of executive privilege. The first is just the timing, as I've already mentioned, that this had been going on for a long time, and it is only right when we are about to begin a hearing that they suddenly come in and invoke this privilege. The second absurdity is that this is not at all what executive privilege is meant for. Executive privilege is a facet of the separation of powers that is designed to protect the president's internal deliberations, so that, for example, his advisors can give unvarnished advice when it comes to policy decisions and don't have to fear that anything they say, even if it's advice that the president doesn't ultimately take, will suddenly be made public. That is the purpose of executive privilege, is to protect these internal deliberations of the president on matters of policy. This is an entirely different situation. It's not pertaining to the collaborative discussions involved in policymaking. Rather, it is the adversarial situation of an investigation of the president himself and the president's interview with his investigator. There was no decision on the part of the president that was being made. It was a decision on the part of the special counsel that was being made as to whether or not the president ought to be charged with a crime. And so the justification for executive privilege simply doesn't exist in this scenario. The third absurdity is that the president had already waived the privilege. At the time that this was invoked, that we received the letter yesterday, we already had the transcripts of the interview that had already been produced. So how exactly is it the case that the transcripts of the interview are not privileged, but the recordings of the interview are? The fourth absurdity is that the justification for invoking the privilege completely contradicted the justification that the Attorney General had been giving for not complying with the subpoena and handing over the recordings. The Attorney General has maintained throughout this process that he doesn't need to hand over the recordings because they are cumulative, meaning they're the same as what has already been produced, so they don't need to keep producing the same thing. But now we have the president's counsel coming in and saying that no, they're actually different. They're so different, the transcripts versus the recordings, that one is not privileged and the other is. The fifth absurdity of this letter from the president's counsel is that it explicitly cites a political motivation for invoking the privilege. The president's counsel, Edward Siskel, states a fear that the recordings will be used, quote, for potential political gain. Suffice it to say that a fear of political fallout, a fear of adverse political consequences, is not an adequate basis for invoking executive privilege. Now, of course, the letter tries to couch it a little differently. The letter says, well, what we're actually afraid of is that the recordings are only being requested for political purposes, and that once they are obtained, they'll be sliced and diced and used to politically damage the president. But that amounts to saying exactly the same thing as we fear the political consequences of handing over these recordings. There is no precedent, nor will there ever be a precedent in any court or otherwise for executive privilege to be invoked explicitly for political purposes or to spare the president political embarrassment. The final absurdity of this invocation of executive privilege by President Biden is the claim that there will be a chilling effect if he hands over the recordings, that this will make it less likely that witnesses will cooperate in future law enforcement investigations. And there are several layers of absurdity to that claim. The first, of course, is that they have already produced the redacted transcript of the interview. So they're saying there's not going to be a chilling effect for cooperation if someone knows a transcript could be revealed, but there will be a chilling effect if the actual recording will be released. But the problem is deeper than that. Because the statement I just read, the justification that was given by the Attorney General and given by the President's counsel is that this is going to deter witnesses from participating in the future. But the President is not a witness. He was the target of an investigation initiated by his own Department of Justice. So what exactly is the chilling effect here? Who does it apply to? The only possible future scenario that this could affect is if at some point in the future another president is under investigation by his own administration. And so what is the fear? That if we release the recordings here, then that future president will not want to sit for an interview? Well, the president in that situation would have to answer for his refusal to cooperate, which would be a pretty good incentive to be cooperative in the first place. So whichever way you look at this, there is simply no legitimate basis for invoking executive privilege in this scenario, which is why the Judiciary Committee did move ahead yesterday and pass a resolution citing Attorney General Garland for contempt. I would encourage the President and the Attorney General to assure that this does not have to go any further. And the way to do that would simply be to hand over the requested recordings. Let the American people see them for themselves. Truly, the President should never be in a position where he deprives the public of information of this kind, and especially when it pertains to vital matters of his competency and culpability with respect to the matters being investigated. This is a clear case of the public's right to know, and so I would encourage the administration to do the right thing here, albeit very belatedly.